Health and prosperity.
Thank you.
Yes.
May I please your lordship. Well, item 16, my lord, I have some difficulty, my lord. I am not physically loyal, my lord. So that will be adjournment. Item 116.
After a week on a date to be fixed by the registrar.
Obliged.
May I please?
Yes, Mr.
Item 26, my lord.
Hmm.
This file already taken back, my lord. But our name is always shown in that was this, my lord.
Item
26, madam.
26.
File already loaded.
Verma. He- Do one thing, you intimate the petitioner.
Yes, my lord. Already, I have checked the order sheet, my lord. And they have filed I, my lord, and guess another council, my lord.
Is
But
it?
their name not shown in the
We'll
code.
just see.
There is the problem.
Just a minute. Just a minute.
Yes.
Yes, Mr. Das.
Item 13, my lord.
Huh.
My lord, I have missed the file, my lord. Maybe list after some days, my lord.
After a week.
May I please your lordship. I am back to mention item number 9, lordship. On behalf of MSP Bora, lordship. She is out of station, lordship. That's why I have been instructed to pay for with your lordship for adjournment, lordship.
Okay.
Item 9, lordship.
After a week.
Deeply obliged, me.
May it please your lordship. Lordship, regarding item number 29, the opposition is yet to file their affidavit. The
Hmm.
detention period of the detainee will be over by 18 January. So, your lordship may kindly fix a short date for the affidavit, for the filing their affidavit.
Give us a date.
By next week, your lordship, because
10th.
10th. Okay. Obliged.
Lordship, I beg to mention item number 5 from the daily post list. The matter may kindly be adjourned for the day as my senior has medical emergency.
Item number 5.
5 from the daily list.
What's your good name?
Asif Ilahi.
Who's your senior?
Mr. J. Hamad.
This is the date of birth. That Mr. Jetamat is in this post. This was, very good.
Highly obliged.
26.
Mr. Abdul Ahmed, counsel appearing, learned counsel. submitted that earlier he along with two others were engaged by the petitioner as his counsel, and the brief had already been taken back from them. Mr. Ahmed also submitted that a new set of counsels have entered appearance on behalf of the petitioner by filing their wakalatnama, but their names have not been reflected in the cause list. From the records, it is seen that the petitioner on 02/08/2023 filed the miss case number 62/2023 for restoration of the review petition 57/2022 that was dismissed for non-prosecution on 14/03/2023. Along with the said miss case number 62/2023, a new set of counsels for the petitioner, namely M.R. Sodial, Mr. Likuro, M.S.S.Z. Hayat, Muhammad M. Hassan, and Begum H. Shenin file wakalatnama for the petitioner. And the court on 14/08/2023, after hearing the said set of counsels for the petitioner, restored the review petition in view of the above. Registry shall reflect the name of the factor number in the cause list for the petitioner in place of substituting the name of the original number.
Publish.
Badly. My lord, I'm sorry, my lord, I'm paying time in this matter, my lord. After 2 weeks, my lord.
On the prayer of Mr. M. Barboya, matter is adjourned for a week on a date to be fixed.
Diploma.
LCF may be retained at this. Yes, please read the order at page 19.
19. This Wandam Forest Border Nago has made this advance against the respondent Masjidullah. The show the allegation made that the respondent is foreigner who entered India illegally after 25th March 2021. Notice was served upon the respondent, but the respondent maintained and absent without taking any step in the reference. As a result, the reference is hard and research expert in expert module.
Please proceed.
Gone through the record and heard the lands LGT for the state. From the record, it is found that the respondent neither appeared in the tribunal nor filed a written statement. He also adduced no evidence, oral and documentary, to prove that he is not a foreigner. The respondent has already failed to discharge his mandatory burden to establish that he is not a foreigner as alleged by the state. If he is not a foreigner as alleged by the state.
Then,
The reference has hereby remained unrebutted and unshaken with the allowed accordingly as stated for by the state with opinion that respondent is Lullah, son of late Lullah of village Kengking under Kaki station is a foreigner who is illegally entered into India after 25th March 1971, informed this one in the police border of Hojai for taking necessary information.
what is your stand?
My lord, he received no copy of.
He did not receive notice.
Received.
Please take your seat. Yes, madam.
Lordship, the records are there. Where was it hanged, Lordship? Does it say in a tree? So the notice not properly served,
So
Lordship.
basically, but hereafter, the petitioner came to know
Hmm.
during the NRC updation that his name is not there. Then he approached the court, the
Hmm.
tribunal. Now this time he approached the tribunal, filed a petition without any provisions, nothing, without any verification, without any affidavit, just with the prayer. So ultimately, as you know, that application was also settled. Hereafter, the petitioner has filed this writ petition without giving any date.
No date.
Date of filing is not there in the writ petition by the concerned lawyer. But anyway, officially it was received on 15th of December 2020.
Yes.
So this order,
It,
we are
it,
setting aside.
it may go back, but the thing is,
The
he,
sister will pass the order.
And ask the petitioner to appear before the tribunal by 22nd of this month, January. And from the date of appearance only, the appearance has to be filed, and we'll pass a direction to dispose of the matter within this case.
Lordship may
Along
even,
with NWS, file the evidence and affidavit also, so that it can be disposed of.
I have a small submission, Lordship. In this petition, we need no document to show the link with his father prior to.
Not necessary here. Only
Yes.
we are rejecting this, we are allowing this petition from the record. We found that the notice was
Not,
hanging in a tree.
not served
It
properly.
was not as per the 1964 rules.
Yes, Lord.
So are also as the terms laid down by the honorable full bench. So that's why accordingly we are setting aside this order.
Yes, Lord.
And then pass a fresh order. But directing the petitioner to appear before the tribunal, as my sister has said, on 22nd, along with the written statement and the evidence in affidavit.
Yes. And a fixed time may be given for disposal. Because
That in
otherwise
accordance
they
with law
can.
will not specify anything.
Yes,
We'll make it clarify that the petitioner, the procedure will appear regularly as and when the matters are fixed. Disposed of with direction. Sister on the board. Madam Ellie. Yes, Mr. Bedi.
No, this taken up with judgment out of the Central Administrative Tribunal matters. No, this search sheet was interfered, madam. Search sheet, madam. Search sheet is not page on page 11, madam. Search sheet, madam. This was interfered, madam, by Honorable Central Administrative Tribunal, madam. This the judgment is, my lord. This last, my lord. It is started from, my lord, 339. Here, my lord, this, the respondent was, my lord, deputed, my lord, for the procedure inquiry, my lord.
Let us see the OA first.
Yes,
OA starts at which page?
yes, sir. OA is from, my lord, OA is from 23, my lord, page 23.
Now, in the OA, what is the prayer made?
Prayer, my lord, let's set aside set aside
Just a minute. Where is the prayer portion?
this prayer portion is, my lord, page 131.
No.
OA, my lord. OA prayer, my lord.
Relief sought for.
Yes, my lord. Please to consider the issue notice, respond, admit, color census, and please to set aside the impugn memorandum dated so and so. This only prayer, my lord, to set aside the search sheet, my lord.
Where is the search sheet?
Search sheet is my lord, page 11, my lord. Page 11, my lord.
Yes, what is the order passed by the tribunal?
Tribunal days, my lord, tribunal is my lord days, last, my lord, starts from my lord. Page 339, my lord. The relevant portion, my lord. Start from page 340, my lord. And ultimately, this findings, my lord, this findings, my lord, from paragraph 5, page 344. 344, my lord.
Take your seat. Where is the inquiry report? Submitted by the
Inquiry
applicant.
inquiry report is not here, my lord.
Why? Initially, there was a discrete inquiry.
Yes, my lord.
In the discrete inquiry, a particular
Yes, my lord.
officer was found to be of his involvement in certain
Yes,
issues regarding his
Yes.
transfer or involvement of some.
yes, my lord.
That was a discrete inquiry which has no value.
Yes, my lord.
Thereafter, a disciplinary proceeding was initiated,
Yes, my lord.
where the applicant was the inquiry officer.
Yes, my lord. Senior. He was a senior most, my lord.
He was the inquiry officer
Yes, my
who was supposed to submit the
lord.
inquiry.
Yes, my
The disciplinary authority appointed him as the inquiry officer and he submitted the report.
lord. Yes, my lord.
The disciplinary authority was not happy with the inquiry report.
Yes, my lord.
And the same disciplinary authority initiated a proceeding against the present applicant, the
Yes.
present respondent.
Yes, my lord. This is the-
What is the illegality in the order of the tribunal?
My lord, question, my lord, the search sheet was filed, my lord. This,
Listen.
it was used, it was,
Listen. In a discrete inquiry by some of the officers, right?
Yes.
There was a finding
yes, my lord.
that Mr. A had committed this wrong.
Yes.
But that inquiry has no value.
Yes, my lord.
That inquiry has no value
Yes, my lord.
because without any evidence, nothing.
Yes, my lord.
Then against Mr. A, the disciplinary authority initiated a departmental proceeding
Yes, my lord.
where the present applicant, who is the respondent herein,
Yes, my lord.
was the inquiry officer. because the disciplinary authority appointed him as an inquiry officer. After taking evidence and everything, the inquiry officer, the present applicant, submitted a report.
Yes.
And the report was in favor of the Mr. A.
Yes, sir.
Now, being annoyed with the said report of the inquiry officer.
Yes.
The disciplinary authority initiated a departmental proceeding against the inquiry officer.
Yes,
Have you ever heard of this kind of action?
my lord, my
Have
lord.
you ever heard?
Yes, that is,
Now, have you, because you
That
do
is-
lots of service matters,
that is true, my lord.
can you show us any instances or any such case before any high court or any tribunal? What
That
is this?
That is true, my lord.
What is this?
I
Now,
understand,
what is the misconduct?
I understand.
Where will you find the misconduct?
This
If somebody on the basis of evidence,
escort department, my lord, this, I'm, yes, sir.
this kind of highness, Mr.
I
Committee,
understand, I understand, my lord. I also discussed, my lord, with the department, my lord.
think over whether the department will withdraw this petition or something else you want.
Then, my lord,
See, department is department.
I understand,
Department is not the disciplinary authority.
yes, ma'am.
The disciplinary authority always exercise their powers with a high hand note.
Yes.
Right? They consider themselves to be boss. The disciplinary authority either to accept that inquiry report or to reject it.
Yes, ma'am. That is true.
Now, being annoyed with or not being agree with or not being happy with the report of the inquiry officer, can he initiate a disciplinary proceeding against that person?
Excellent. I have to discuss this beyond this point, my lord, but.
What is misconduct?
I understand.
Where will you find out? Where will you show the willingness?
Yes, ma'am. So I'll take inspection, ma'am, on the next date, my lord.
What is this? Don't come along with this kind of petitions
Yes,
before this court at least.
Yes, ma'am. On 11, my lord, I'll,
Whatever they say, you will not file a petition.
this is true, my lord. Yesterday, I told them, my lord.
From tomorrow, officer in your department, nobody will able to accept it. If this kind of things happen.
My lord, department, something is that this type of happening sometime, my lord, but not always, my lord. But here sometime, my lord, they actually, the allegation, all those in record in my lord,
See,
it was not
if
considered.
necessary, you could have removed that
Yes,
inquiry
that is
officer.
true, my lord, that is true, my lord.
If you have anything
Alright,
to.
yes, ma'am.
Because by in case manner, you have a presenting officer. That presenting officer would have been informed you.
I understand, my lord, I understand.
This kind of thing.
Yes, ma'am. Only they
As
are,
because the inquiry report submitted by inquiry officer was in favor of the delinquent
no, my lord,
officer.
this record, my lord, in the file, those who are with the inquiry officer, it was not, my lord, reflected in the inquiry, my lord.
That is the
Yes,
reason.
yes,
The disciplinary authority could have rejected that
yes,
inquiry.
that is true, my lord, yes, I
That
understand.
doesn't mean that you will be initiating a disciplinary proceeding against the
Yes,
inquiry
yes,
officer.
yes. So, that, on 11, my lord, I'll take instruction and, whether they will draw or they'll take,
This is not fair.
yes, my lord,
On the prayer of Mr. S. K. Mithilan, please. Matter will be listed again.
11 minutes.
Let me lordship, the contested case lordships. Impugn order lordships, page 60, read lordship. And after 7 lordship. Damn discrepancy lordships. Only the linkage is there, lordship.
Please take your seat. Yes, Ms. Verma, what do you have to say?
Lordship, this opinion is very detailed and everything has been covered.
Let the record be called.
Yes, Lordship. Lordship may examine the records.
Nuclear fault. Nuclear fault.
Huh?
Nuclear fault.
Anyone for the response number one, any CGC here?
No, Lordship.
NMS paper. Standing Council Home Department.
No, it's no, Lordship.
And 4. Okay. Representing the Assam for the response number 3. And Mr. A.I. Ali, Standing Council Election Commission of India for the response number 5. No representation on behalf of the Union of India, response number 1. In FT case number 806/2017. Within bracket arising out of IMDT case number 1569/2003. By the impugned order 23/11/2023. Land member Fairness Tribunal Potali. Opine that the petition after hearing opine that the petitioner is a foreigner under the Foreign Act 1946 who had illegally entered into territory of India within the Assam from the specified territory on or after 25/03. Dissatisfied with the said opinion, dated 23/11/2023. The petitioner has filed this writ petition D1/12/2023. It's a notice returnable by date. Appear before the Superintendent of Police Board or better. On or before 19th of January. Let's
Diploma obliged. May have lordships. My lord, we have challenged the impugned order that lordship may kindly see page 55.
35.
55. 55.
Yes.
40% lordship may kindly see page 57, second para. In her statement, the proceeding claimed to be an Indian national by birth and stated that she is the legitimate daughter of Khandakar Jamaluddin alias Rashid Jamal, Bodiud Jamal, Khandakar, Bodiud Jamal, and was born at village Kokila, Maulvipara, post office Kokila, circle Sijangram, PS Marsalmara, district Gwalpara, and Gwalpara, undivided Assam. And after birth, she lived in the said village till she became a major, and as such, she is an Indian national by birth. The proceeding further stated that she got married with one Aizul Haq of village Bangaldova relief camp, post office Naikgaon, PS Kokrajhar, BTD district Kokrajhar, and since her marriage, she has been living with her husband. The proceeding further stated that the name of her grandfather and father appear in the NRC 1951 and in the electoral rolls 1966, and name of her father also appears in the electoral roll of 1970. Proceeding in her evidence adduced by you of affidavit deposed that she is the daughter of Khandakar Jamaluddin and was born and brought up at village number 2, Sarkasi Busti of Sarkari Busti Gaon Panchayat and Lanka Revenue Circle, Nagaon district, Assam, established a link certificate number so. She is the daughter of Khandakar Jamaluddin, and that the headmaster of Puran Bijli Batinia, Emi Madrasa, issued her a link certificate, Exhibit 2, to show that link with Khandakar Jamaluddin as her father, and she got married to Aizul Haq of village Bangaldova relief camp, producer certificate, Exhibit 3, to show that she is an inhabitant of village Bangaldova relief camp, and that the Khandakar Abdul Majid is her grandfather, and Khandakar Jamaluddin is her father, and their names appear in the NRC of 1951, and exhibited a copy of the NRC 1951 as Exhibit 4, and a copy of NRC details marked as Exhibit 5, and that the electoral roll of 1966, the name of her grandfather is enrolled as A. Majid. A. Majid means Abdul Majid. And name of her father is enrolled as Basat Jamal, and exhibited a certificate copy of the voter list of 66, which was obtained in the year 1997 as Exhibit 6. And that the name of Khandakar Abdul Majid is recorded in the voter list of 1959, and exhibited a photocopy of the voter list 1959 as marked as Exhibit 7. And that in the voter list of 1970, the name of her father has been recorded as Basit Jamal at serial number so-and-so, house number so-and-so, exhibited, and exhibited certificate copy of voter list 1970, Exhibit 8, that her ancestors possessed land in Assam, and exhibited as cell deed as Exhibit 9, which is of the year 1978, dated 2378. And her father lived at Bangaldova camp. Now, Lordship would kindly see her exhibits. I have made it clear. First thing, my lord, she has exhibited various lists of voter list that Lordship may kindly see. Page that means on page 67. Here, the exhibits have been written. That is in vernacular, in untyping, not typed, but typed copies Lordship may see page 97. Page 97. Her own name. Voter list of 2005. Saleha Khatun, wife of Aizul Haq. It is voter list of 2005. Then Lordship would see at another voter list 2010, page 99, with Aizul Haq as her husband. Then my lord would see page 101. This is her voter list of 2017. So far, the other voter lists are concerned, that Lordship may kindly see page 14. Page 14. It is the NRC, page 14 NRC, Khandakar Abdul Majid, who is my father. Sorry, who is my grandfather. Khandakar Abdul Majid is NRC in the name of Khandakar Abdul Majid. And here my father's name is also there, Khandakar Jamaluddin. serial number 7, and son of Khandakar Abdul Majid. Abdul Majid is my grandfather, and my father is Khandakar Jamaluddin, and both of their names appear in the NRC. Though NRC is not the proof of citizenship, but even linkage may be accepted. Now kindly see page 16. This is the NRC details. The same thing is also recorded there. Then Lordship, these are all exhibited documents. Now next is, my lord, page 18, voter list of 1959. In the name of Khandakar Abdul Majid, page 18, who is my grandfather, and my father's name is also there in that list, that is Khandakar Badiul Jamal Mia. Here Mia is written. So for that we have also exhibited an affidavit regarding the anomalies in names. Those are also here in the record, my lord. Lordship may kindly LCR, that is in record and also duly exhibited. This is the voter list of 1959. Then Lordship would see page 21. This is the voter list of 1966. In the name of my father, Rashid Jamal. And Rashid Jamal is my father. Name difference is there, I have already told, but my grandfather's name is A. Majid. And village, Lordship would see village Maulvipara, Kukila Maulvipara. That was my initial claim, that I took birth at village Maulvipara, Kukila Maulvipara. So my father's name appears in the voter list of 1966 as serial number 90, house number 21, and my grandfather's name appear in serial number 21 top of that voter list. The entire family members' names are there. The same village, Maulvipara. Now, Lordship will see kindly page 23. This is the Panchayat certificate, Lordship. Here, Lordship would say Saleha Khatun, the proceeding, daughter of Khandakar Jamaluddin, village Sarkari Busti Gaon Pansayat under Lanka Revenue Circle of Nagaon, district of Assam, who is aged about 22 years. My lord, what happened? Actually, they were the original resident of Kokrajhar. After marriage, she resided at Kokrajhar. But at Kokrajhar, at that relevant point of time, that is in the year 1995-96, there was some communal clashes. So these persons had shifted to their village to relief camp. And then also they went to Nagaon. That's why it is there. And this certificate has been duly authenticated by SDO. By SDO, Lordship would say here, Secretary, Sharke Bosti Gaon Panchayat, and photocopy senior, it is duly exhibited, Senior Assistant Foreigners Tribunal, Dhubri. So that is there, and it is countersigned by Block Development Officer Tarun Chandra Das. And Tarun Chandra Das is one of the witnesses. He has adduced his witness. That I am coming later on. Regarding the anomalies in names and ages, my father has shown an affidavit that may be seen page 25. So in some places, his name is written, my correct name is written, kindly see para 2. My correct name is Khandakar Badiul Jamal Mia, which has been recorded in the voter list of 1959, house number so-and-so, serial number so-and-so, Abhayaburi North Sharma LSC. At that time, it was North Sharma PS as North Sharma LSC. Now there is no North Sharma, Abhayaburi South, Abhayaburi North. The names are changed, but places are the same. Then Lordship would say, Abhayaburi SC LSC mentioned as Rashid Jamal, and also recorded in the voter list of 1989 by serial number 212, house number 67 under 34 number of Abhaypuri North LSC, mentioned as Khondo Jamal Basha instead of Khondokar Budiud Jamal. That Khondokar Budiud Jamal, Mia, Rashid Jamal, and Khondokar Jamal Basha are the same and one person which relates to my name alone. So, Lordship would see those things are exhibited and there was no cross-examination to demolish the statements made in the affidavit. Then Lordship would see the certificate of Gaura, page 28. The aforesaid person is a resident of above mentioned locality. When I went with my husband to Lanka, that certificate was issued. The aforesaid person is a resident of above mentioned locality. Her father's name appears in the voter list of 2016. So at that time, what the Gaura got, accordingly he issued the certificate. But it does not mean her name or her parents' name do not appear in a voter list. That does mean. At that time, what he knew, that Gaura, accordingly he issued the certificate. That is also exhibited. Now, Lordship would see page 30. It is also same thing. Khondokar Jamaluddin, Mojid Khondokar. Mojid means my grandfather. Then my father's name, election ID, that is page 32. Election Commission's ID, Khondokar Jamaluddin. So it is written and son of Mojid Khondokar. So this page 33 is my WS. Here, Lordship, I have annexed one certificate also. School transfer certificate in the name of Saleh Khatun, page 34, kindly see. Page 34, para 7, Roman 2. School transfer certificate in the name of Saleh Khatun, daughter of Khondokar Jamaluddin, issued by the headmaster of Quran Bizni Batini Ami Madrasa, tendered by the proceeding in order to prove of her linkage with her father. Serial number shows. The proceeding got married to an Aizul Haq, village Bangaldova. So these are common things. In the initial stage, when I appeared before the learned tribunal, I have made all these statements and those are supported with public documents. And there is no cross-examination which can demolish my statements. And they have not challenged the authenticity of those public documents. Now, my lord, all in a sudden by oral statement, those cannot be denied. So these things are there. Then Lordship would kindly see page 42 is my evidence, which page 42. In my evidence, it is just like my WS. Then Lordship would see another witness, that is my lord. That may be seen, my lord, page 117, Khondokar Budiud Jamal. So it is my father. Then DW2 is Praveen Brahmo. Praveen Brahmo, chairman PCDC, who issued certificate. That may be seen page 120. And DW4 is Tarun Chandra Das, BDO. So, my lord, so far my burden to discharge the my liability that I have done. My father has witnessed. I have also adduced my witness, also supported by WS. When father comes and says that Saleha is my daughter, and father's name appears in the voter list of 1966, I think there is nothing to be doubted, my lord. Nobody will dare to say that she is my daughter and my name appears. And if that is not the case of the prosecution also, they did not say no, it is incorrect. And they could also file a case if I have made any false statement. So, my lord, my humble prayer is this: I have discharged my burden as required. Now, once they should have been shifted, but they have not done that. In that view, my lord, my case may be considered, and accordingly order may be passed that I am not the illegal migrant or foreigner, as has been declared by the learned tribunal. That should be set aside. That is my humble prayer. There are some anomalies. Those anomalies are common in the names. Lordship is aware, since lordships are dealing. These are common. Even 5 times, 10 times names, if you are told, they write the wrong names. For anomalies in wrong names, lordship, it is Sirazul Haq's case, and Abdul Mutali's case, and Mutiur Rahman's case. So many cases are there. So, so, my lord, our submission is this. Not only my father and I, also the BDO and the VCDC secretary, they adduced witness. And the details, my statements details are there, my lord, not only in WS. And this is also, the learned tribunal made some observations regarding, my lord, the finding. For instance, I draw your lordship kind attention. Kindly see the improved order, that is page 55 for a moment, my lord. What a portion may be seen, what the observation of the learned tribunal. I am drawing your lordship attention. In my humble opinion, my lord, those interpretations are totally incorrect. Now kindly see, my lord, page 59 bottom. 59 bottom. Here, Lordship would say, Exhibit 1, bottom after 5 lines, before from the top 5 lines, Exhibit 1 has also specifically deposed before the court on note that the Exhibit 1 certificate has been issued to him to show that Saleha Khatun is the daughter of Budius Jamal, and that Exhibit 1 certificate has been tempered to show that Saleha Khatun is the daughter of Khondogar Jamaluddin. The BDO Tarun Chandra Das, while identifying the signature on the document to be his signature, has deposed that he has not issued any certificate that Saleha Khatun is daughter of Khondogar Jamaluddin, and produced the counter folio of Exhibit 1 document before the court, and he stated that certificate Exhibit 1 produced by Saleha Khatun is a fake document. On examining the counter folio of Exhibit 1 document, which is dated 22/7/15, bearing serial number songs, it found to tally with that of the original document, which also bears the date 22/7/15 and same serial number. But in the counter folio of Exhibit 1 document, it is found that the name of the father of Saleha Khatun is written as Budiruz Jamal. So Budiruz Jamal, Lordship, I have stated that there are some anomalies in names, but in the original certificate, it is shown that Saleha Khatun, daughter of Khondokar Jamaluddin, who goes to establish that in the link document Exhibit 1, the name Budiruz Jamal has been removed and has been interpreted to show that Saleha Khatun is daughter of Khondokar Jamaluddin. So, my lord, here Jamaluddin and Budiruz Jamal. So, this thing, there is a question raised by them. For a moment, my lord, if we disbelieve this, it is clearly said Exhibit 1 document which is dated so and so same date. But they say there is some tempering. Now, if for the tempering, my lord, if this document is totally disbelieved for the sake of argument, then voter list, my lord, then Gaubara certificate, then VCDC certificate, a voter list of not only 66, 59 voter list. Now, Lordship is coming, Exhibit 2, kindly second paragraph, page 60. Now coming to the document exhibit 2, which is school certificate issued from the school on 2011-15, showing that Saleh Khatun is the daughter of Khandokar Jamaluddin of village Puran Bizni. But as there has already been an interpolation of the name of father of proceeding in the document exhibit 1, the document 2 is not a reliable trustworthy. Why? Suppose, my lord, here kindly see the interpretation of the learned tribunal. As there is some doubt in the exhibit 1, so exhibit 2 school certificate he does not want to accept. That is not the law. One certificate may not be up to the standard. But here, when the school certificate is there, Lordship is aware that the school certificate should be accepted even if the headmaster does not come to any seminar, because. So the tribunal says that as exhibit 1 has been not accepted, so exhibit 2 cannot be considered. So this view is totally incorrect. Then Lordship would say, now coming to the document number 3, which is certificate of show that the proceeding is the wife of Muhammad Aizul Haq and an inhabitant of village Bangal Doba relief camp, as it is a document to show the link between husband and wife and not proved by examining the issuing authority, it is not admissible in evidence and has also no relevancy. Now, so for husband and wife, that is a corroborative piece of evidence, not the evidence. Husband and wife, the person gets naturally from father or at best parents. But here husband, only for the sake of that, earlier we were at Kukila Molivipara, now we have shifted along with husband Aizul Haq. Then Lordship would say page 61. Now coming to the document exhibit 4, which is a copy of the NRC 1951, showing the names of Khandokar Abdul Majid and Khandokar Jamaluddin, whom the proceeding has projected as her grandfather and father respectively. But as the said document is a mutilated and incomplete document and not showing the age of Khandokar Abdul Majid and Khandokar Jamaluddin, it is not admissible in evidence. How a funny finding. Now, as has to be written by the authority. Now, my duty is that I have produced a document. Whether you accept this as genuine, if the authority, NRC has been issued by the authority. That is the election commission. At that time it was issued, I think, election commission. Now, Lordship would see there is no showing the age of Khandokar Abdul Majid. What can I do? It is there, they have not written. If I write something, they would say it is tampered. If I do not write anything, they say it is incomplete. If incomplete, now it is your duty to prove that it is false. That is not their plea. That is the plea that incomplete. But what can I do? I cannot edit anything. Now, next para, coming to the document number 5, is the photocopy of NRC details. That is, I am not discussing because NRC is not the proof of citizenship. Third para, kindly see. Now, coming to the voter list of 66, Exhibit 6, and voter list of 1970, Exhibit 8, by which the proceeding claimed that the name of as serial number 90 of voter list of 66, and the name as serial number 90 of the voter list 1970 is the date of her father. But it is found that the name appearing as serial number 90 of voter list of 1960 is that of one Bosot Jamal, and name appearing as serial number 90 in the voter list of 1970 is that of one Rashid Jamal. So, Lordship, we have clarified this in our affidavit. That is exhibited. So, these are very crucial documents, 66 and 70. It is disbelieved by the learned tribunal only on the ground. There are some differences in the names and ages. But for that, we have sworn in an affidavit that is exhibited. But there at that time, there was nothing. So, next, Lordship would say, Exhibit 8, last 3 paras, hence the voter list of 1966, Exhibit 6 and voter list of 1960, Exhibit 8 are not reliable and trustworthy. Well, this very fantastic finding. If voter lists are disbelieved, how the people will prove their citizenship? Nobody can prove, my lord. We will fail to prove. They do not say it is false. They say not proof. What? I have adduced evidence. I have also said that this is my father of village so and so. That is required under section 67 of Evidence Act. So that I have discharged. Now they say it is not believable, trustworthy. Then you are always displeased. Learned tribunal is always displeased. Now coming to the document number 5, which is cell deed of the year 1978. Being a post of 71 document, it has no relevancy. So my lord, what is this? Because before 71 I have given, you do not believe. After 71, I have given that it is after. So my lord, it is what I will say. Learned tribunal is not satisfied. I do not know why. Satisfaction should be on the basis of the law established under proper rules. Now, when the law says that public document, that is section 74 of the Evidence Act, that should be believed. A person has passed HSLC examination. He has submitted his admit card, and he is proving that this is my admit card of HSLC examination. But the secretary need not come because this is public document. Similarly, voters of 66, 70 are public document. It is issued by sovereign and competent authority. So these are the things, my lord. In this regard, my lord, of course, I am presenting 2 books to my learned judges. I have written a book on these points. So in this regard, I have presented. So from my side, I am presenting these 2 books, my lord. It is published shortly. And I will also provide one thing to my learned friend.
Thank you.
Please take this.
Thank you.
So my lord, also would see that so far my limited capacity, and my lord, these are very poor and humble lady. We cannot expect that they would prove their case like a intelligent or like a lawyer. So what they can possibly in their that stage, she has done. Now, so I think my lords would kindly consider all these aspects and would be pleased to declare me as Indian citizen or not of India, setting aside the order of learned tribunal. That is my humble prayer. Okay. Getting alumnus names, I have met so many. Some I have given here. My lord, if your lordship kindly see table of contents. So I have given legal value of electronically generated documents, 30 years document, school certificate, governance certificate, anomalies in names and address. That's you see in my book. Those are 2 honorable judges have also commented on this. And then interpretation of documents, burden of proof, malafide investigation, review and expert opinion, public documents, limitations, delays, evidence, NRC related documents, electoral rolls, fair trial and fair investigation, documents of close relatives, members, if they are declared as Indian, linkage, service of notice, role of public prosecutor, general rulings. Then I have also given some history of Assam and the UNS report regarding some human rights in India, UNS and the Muslim Mandal case, which went to UNO. Muslim Mandal case have gone up to UNO. And UNO has given a comment on that and asked the Indian government to look into the findings of the full bench of this Honorable High Court. Those are, I have also annexed here. Lordship would kindly consider.
Yes, Ms. Verma.
Lordship, we can come directly to the opinion, Lordship. Page
Yes.
58, decision with reasons, Lordship. My friend has read it. I'll read it again, Lordship.
Kindly read.
On examining the records, written statement and the entire evidence and documents produced by the proceedee, it is found that the proceedee during the inquiry could not produce any documents to prove her citizenship. From the facts stated by the proceedee in her written statement and depositions in her evidence on affidavit, it is found that the proceedee has herself contradiction her place of birth. Lordship, this is my first thing. Her own contradictions are there all along in her proceeding, Lordship. In paragraph 6 of a written statement, the proceedee has stated that she got birth a village Kokila so-and-so, North Salmara district, Gwalpara, Assam. After her birth, she lived in the said village up till her majority, and as such, she is an Indian citizen by birth. Whereas at paragraph 2 of her evidence on affidavit, the proceedee deposed that she was born and brought up at a village
You are
number
reading at
2,
which page?
page 59, Lordship. It is 59. First paragraph, Lordship.
No.
I have started with the decision with reasons of the member, Lordship. Started at page 58, last paragraph.
Hmm.
I'm reading it.
Decision of the reasons you're.
Yes,
reading, right?
Lordship. Because that is what is we need to discuss, Lordship. That is what Lordship needs to look into, whether the documents have been properly examined by the member or not, Lordship. Her first contradiction is her place of birth, Lordship. In her written statement, she has written something else, and in her evidence on affidavit, she has deposed that she was born and brought up at a village so-and-so, which is in Nagaon district. But in the written statement, she has stated Gwalpara, and here it is Nagaon, Lordship. As such, the claim of the proceedee that she is an Indian citizen by birth cannot be accepted to be true. The proceedee has failed to establish her birth in India. Now, on analysis of the documents, it is found that Exhibit 1 is a linked document to show that the proceedee is the daughter of Khandakar Jamaluddin. The issuing authorities of the linked document were examined to prove the contents of the document. During the course of examination on oath, the issuing authorities of the linked document deposed before the court that the linked document Exhibit 1 was issued by them to show that Saleha Khatun, the proceedee, is the daughter of Badrizur Zamal. Lordship, this name will keep on cropping again and again everywhere where the authorities have come and deposed before the court, before the tribunal, that her father is Badrizur Zaman and not Khandakar Jamaluddin, Lordship. The GP secretary of Sarkari Basti Notun Bazar Gaon Panchayat, who has issued the linked document, has specifically deposed before the court on oath that Exhibit 1 certificate has been issued by him to show that Saleha Khatun is the daughter of Badrizur Zamal and has been issued with him on verification of the voter ID card of Saleha Khatun and voter list of 2014. Lordship, voter list of 2014 of the father, projected father, not any voters list of 66 or in between 66 and 71. The official also identified the signature of the document to be his signature. The Block Development Office of Lumding Development Block, who had countersigned on the linked document, had also specifically deposed before the court on oath that Exhibit 1 certificate has been issued to him to show that Saleha Khatun is the daughter of Badrizul Zaman, and that Exhibit 1 certificate has been tempered to show that Saleha Khatun is the daughter of Khandakar Jamaluddin. The BDO Tarun Chandra Das, while identifying the signature of the document to be his signature, has deposed that he has not issued any certificate that Saleha is the daughter of Khandakar Jamaluddin, and produced the counter folio of the Exhibit 1 document before the court and stated that the Certificate 1 produced by Saleha Khatun is a fake document. On examining the counterfolio of the Exhibit 1 document, which is dated 22/7, bearing serial number 2544, it is found to tally that with that of the original document, which also bears the same date and same serial number. But in the counterfolio of the Exhibit 1 document, it is found that the name of the father of Saleha Khatun is written as Badrizud Zaman. Counterfolio has been produced by the government official, which is in his custody. And the certificates, the numbers are same. The other day also I had produced before this court a sale deed, Lordship, if remembers. The date and the registration number of the sale deed was absolutely same, but the names and the dag number, patta number had all been tampered with. And we have a police report to that effect. Lordship, now I'll come to, it is written as so-and-so, daughter of so established. But in the original certificate, it is shown as Saleha Khatun, daughter of Khandakar Jamaluddin, which goes to establish that in the linked document, the name of Badrizud Zaman has been removed and has been interpolated to show that Saleha Khatun is the daughter of Khandakar Jamaluddin. And as such, it is not a reliable and trustworthy document to prove that Saleha Khatun is the daughter of Khandakar Jamaluddin. And according to linked document, Exhibit 1 being not a reliable and trustworthy document, it cannot be acted upon. There is no wrong in this opinion, Lordship, because the tribunal has called the officers, taken their evidence on oath, and they have produced the official documents to show that they had issued the certificate in the name of the father, which is Badrizul Zaman and not Khandakar, Lordship. So this document and this finding of the tribunal is absolutely correct. It is found that the proceedee, in order to establish that Khandakar Jamaluddin is her father, has resorted to falsehood to prove herself as an Indian citizen. Producing false documents itself goes to show that the proceedee is not an Indian citizen but a foreigner. Now, coming to the document Exhibit 2, which is a school certificate issued from the school on 2011-2015, showing that Saleha Khatun is daughter of Khandakar Jamaluddin of village Puran Bijni. But as there has already been an interpolation of the name of the father of the proceedee in the document 1 and document 2 is not reliable to show that the proceedee is the daughter of so-and-so and cannot be acted upon. Moreover, the name of the village is also different. So there is nothing wrong in this second finding also, Lordship, because in the first statement, which Lordship I just missed out, in her written statement, she has given about 4 or 5 names as her father's name. There ought to be at least 1 or 2, but about 6 names of one father, and she has used it at different places according to her convenience. Now coming to the document Exhibit 3, which is a certificate, top show that the proceedee is the wife of so-and-so. And Lordship, this husband and wife document I'll leave aside because that does not prove the linkage. Now I'll come to page 61. Now coming to the document Exhibit 4, which is a copy of the NRC 1951 showing the names of Khandakar Abdul Majid Khandakar Jamaluddin, whom the proceedee has projected as a grandfather and father respectively. But as this said document is muted, Lordship, this document will also not be taken into consideration as NRC documents are not admissible at the moment, Lordship. So I'm skipping paragraph 1st and 2nd, coming to the 3rd one. Now coming to the voters list of 1966, Exhibit 6 and Exhibit 8. Voters list of 66 and 70, Lordship, by which the proceedee claims that the name at serial number 90 of the voter list of 1966 and the name at serial 90 of the voters list of 1970 is that of her father. But it is found that the name appearing at serial number 90 of the voters list of 66 is that one of Basod Jamal. And the name appearing at serial number 90 in the voter list of 1970 is that one of Rosid Jamal. The name of Khandakar Jamaluddin, whom the proceedee claims to be her father, is not found in any of the voters list of 66 and 70. and there is no explanation to it. It is found that in the voters list of 66 and 70, it belongs to two different persons whom the proceeding has projected as a father to prove her citizenship. And Lordship, if Lordship goes back to page 57 in her written statement also, she has taken these two names of the persons whose names appear in 66 and 70 to be her father. Page 57, Lordship. Lordship, may kindly come to the first line in her written statement. The proceedee claimed to be an Indian national by birth and stated that she is the legitimate daughter of Khandakar Jamaluddin, alias as Roshid Jamal, Basur Jamal, Khandakar Bodjat Jamal. But the real name of the father is not there, whom the officers have come and deposed before the tribunal, Lordship. Hence, the voter list of 1966 and voter list of 1970 are not reliable and trustworthy documents and cannot be acted upon to decide the citizenship. There is no infirmity or any wrong in this opinion of the tribunal, Lordship. Now, coming to the document marked as Exhibit 7, which is a photocopy of the voter list of 1959 and not admissible under the Evidence Act and cannot be acted upon. Now, coming to the document 9, which is a sale deed of the year 1978, being a post-1971 document, it has no relevancy. Now, coming to the document of Exhibit 10, which is a document of the year 2010 in the name of one Baidol Jamal, whom the proceedee claims to be that of her father. Now, the proceedee herself claims that Baidol Jamal is her father and not Khandakar Jamaluddin, Lordship. It is found that Baidol Jamal is another purported father of the proceedee. The document 10 is not a reliable document and cannot be acted upon. Maybe, Lordship, this document could have been a genuine document because it's of 2010, but not the previous documents. Now, coming to the document Exhibit 11, which is an affidavit sworn by Khandakar Bodjat Jamal Mia, whom the proceedee claims to be her father. But the name of Khandakar Bodjat Jamal Mia does not appear in any of the documents produced by the proceedee. Khandakar Bodjat Jamal Mia is found to be another purported father of the proceedee, and hence the document 11 is not a reliable document and cannot be acted upon. Now, coming to the document Exhibit A, which is a link document to show that the proceedee is the daughter of Khandakar Jamaluddin, the issuing authority of the Exhibit A link document DW6 was examined to prove the contents of the document. During the examination, the issuing authority of the Exhibit A document deposed on oath that the name of the father of Saleha Khatun, that is the proceedee, is Bodjat Jamal, and that he has issued the certificate A showing that Saleha Khatun is the daughter of and that he has a daughter of Muhammad Khandakar Jamaluddin. The own deposition of DW6 is found to be contradictory. The DW6 answering court question further deposed that he is not a government officer and he has not been given any authority by the government to issue link certificates. The DW6 issuing authority also deposed that he has not issued the link document from any government records. As such, the link document Exhibit A is not reliable and trustworthy. Now, coming to the document Exhibit B, which is a registered Kabinnama issued on so-and-so, in which the proceedee wants to show that she is the daughter of Khandakar Bodjat Zaman and got married to Azizul Haq and has issued the Exhibit B document as a link document. Lordship, in her own Kabinnama, she has stated her father's name to be Bodjat Zaman and not Khandakar Jamaluddin. So if this one document is to be believed, then this is the father, not the one which they have been bringing all along, Lordship. On being examined on oath, the DW5 who has issued the Kabinnama could not produce his original appointment order as Qazi. On being examined, the DW5 further deposed that his authorized agent performed the marriage, but the proceedee did not examine the authorized agent. The DW5 further deposed that at the time of the marriage, Khandakar Bodjat Zaman was present and is the father of Saleha Khatun. On being examined by the court, DW5, while answering the questions put by the court, deposed that he does not know if Khandakar Zaman is known by any other name, and he has issued the Kabin Nama. Exhibit B, as Saleha Khatun is married to Azizul Haq, and he did not know Saleha Khatun before marriage. As such, Exhibit B is not a reliable document to establish a link by the proceedee with her father. From the materials on records and discussions above, it is found that the proceedee has herself contradicted her place of birth and has failed to establish her place of birth in India. It is also found that the proceedee has herself contradicted the name of her father in all documents, which goes to show that all persons named by her are her purported fathers. The proceedee has also resorted to falsehood by producing false and interpolated documents to prove herself as an Indian citizen. Apart from the documents that have been exhibited and discussed above, the proceedee has failed to produce any other reliable, trustworthy documents to prove that she and her grandparents existed in Indian soil prior to 25/3/1971. On the other hand, from the materials on records and discussions above, it is found that the proceedee has resorted to falsehood to prove herself as an Indian citizen. So, Lordship, after going through all the documents, the evidence, the officers have been examined, it is clear that the proceedee has not brought in the genuine documents, Lordship, and has resorted to all fake means to prove her citizenship. So she ought to be declared a foreigner, Lordship, and this opinion of the tribunal must be upheld, Lordship. There is no infirmity, no wrong, nothing is wrong here, Lordship. If Lordship can further examine the matter. And Lordship, there are many instances about documents being tampered. Previously, in the previous bench, the Lordships had asked for inquiry of many documents. Most of the documents were proved to be false. Documents on record false.
Well, not a simple clarification, Lordship.
We'll come back to you. Ms. Burma, just take it. We're just trying to find out the position of DW6, right?
Yes, Lordship. Records are with Lordship. For a moment, Lordship, we believe what my friend says, that the documents are true, but the officers will not come and give on oath wrong statements, Lordship. The tampering is there. The documents have been manufactured or not given by the officers. They have stated that before the tribunal. DW6, Lordship. And DW6 has no authority to issue any link certificate. He himself has stated that. And if it's a Gao Buddha certificate, it has no value. If it was only for the purpose of NRC at that point of time. The last segment करने को होता है ये Lordship. No, I haven't seen them, Lordship, but everything is here, Lordship. We can go through them if Lordship desires. Jamaluddin, what
Khondagar
comes
Jamaluddin.
with- Yes. But Lordship, see her Kabin Nama. She herself has stated there the real name of her father. And the Qazi who has come and deposed before the court has also said that the father is not, the father is Boydul Jamal and not thing. There's so many names, Lordship, I can't.
Khondagar Bodiuzzaman.
Khandagar.
Well, one thing, my lord, my learned friend has pointed out one thing rightly. Kindly see page 23, my lord. 23. Here, there it is written like this. This is to certify that Saleha Khatun, daughter of Khondagar Jamaluddin, of village Sarke Busti, Gaon Panchayat under Lonka Revenue Circle of Nagaon district, number 2, Sarkari Busti, Assam, who is aged about 22 years, was a resident within the jurisdiction of the said Gaon Panchayat area. Got married on 14/8/20 to with Aizul Haq, son of Siddiq Hussain. So it is not written that she took birth at village Sarke Busti, Lanka. But surprisingly, I do not know why this thing was written that I took birth at village in the WS. Now Lordship may kindly come to WS. WS here, she has said that,
Page 59, Lordship.
page 59. No, in
Lordship,
WS,
annexure
in
six,
WS,
which my friend is referring to.
in WS, let me say,
Yes, please.
in WS, she has said, page 44, kindly see, page 44, para 2. I am legitimate daughter of my father, Khondagar Jamaluddin. I was born and brought up at village number 2, Sarkai Busti, Gaon Panchayat under Revenue Circle, Lanka. So, on the basis of this certificate, but if this certificate is saying she was for a temporary period at Sarkai Busti. But I do know the advocate concerned, though it is signed by party, here advocate wrote that she took birth at village, born and brought up at village number 2, Sarke Busti. But in all her documents, now kindly see page 34. Page 34, she got birth at village Kukila Moliupar. Actually, this is correct. Now, Sarke Busti, Lanka, for a particular time she was there. But that was written as I was born and brought up. Not born and brought up. It is the drafting mistake. Because all other documents say Kukila Moliupar. So on the basis of this document, perhaps the learned counsel at the tribunal wrote this that she was born and brought up at village number 2, Sarke Busti. Actually, this is against the document. Document does not say that she took birth at village Sarke Busti. Document is saying particular period she was there But in writing, it is that I took birth as circumstance. Whereas in all other writings,
But the
Uh,
birth certificate is not there to show exactly where she
the
took birth.
birth certificate, my
lordship,
learned friend, birth
page-
certificate, my lord, many times not available. School certificate is there, birth
Yeah.
certificate.
School
Many
certificate,
times.
so once we are born, we shift to some other place. School can also be in a different district. And the
The district may be
document,
different. When it's like bird, when goes here, you are a resident of which place? Now you are at Guwahati. I
I
was
was
at
born and
Bongaigaon.
brought up here. I have only one name, one father's name, one mother's
Your
name.
family is
one
learned
address.
family. My family is totally illiterate. Consider this. You are a learned family. My family is totally illiterate, rustic people. So both our comparison is not
No,
actually.
Lordship, the document which my friend is referring to, this cannot be accepted at all because there's a disclaimer below at page 23, Lordship. It says it may be added that the certificate shall be accepted only as a supporting document for establishing linkage with the parents of the aforementioned person for whom the certificate, and this is only for the purpose of NRC, not for any other purpose, Lordship. This document was issued during the NRC to claim, to help the women, especially to show that they belong, that their names of the linkage with the father, Lordship.
Lord,
And it is
my
very
learned friend is
categorically
correct.
linked.
That only for NRC, that is correct.
And but
But
this has
this
been
is a
wide,
corroborative piece.
it has been
When
widely
you
used.
can accept it for NRC, honorable courts in his discretion may also accept, because if NRC, that is also a public document, you are accepting it NRC, and other place you are not accepting. So two kinds of laws. So court has jurisdiction. Court, if there is no law, law is silent, then discretionary power shall be exercised by court. This is
Lordship,
the law.
I would like to refer to 4 citations, Lordship.
One thing, my lord, I am clarifying. My school, that Puran Bizni and Kukila, 3-4 kilometers. Kukila, I took birth at Kukila, I read at Puran Bizni. So distance between this Kukila and Bizni is 3-4 kilometers. My learned friend may visit Google also. So another place I am reading, that is not, because perhaps at that time there was no school at my village, maybe that is the presumption only. So 3-4 kilometers away, if a girl went there to read, or maybe her relatives there, so that is not the reason. There are no doubt there are some discrepancies. Actually, lawyers should be also cautious. They should be cautious in filing this. But otherwise, 66, 70, those things are, my lord, undisputed. Dispute cannot be for the sake of dispute. It must be logical. It must be not shocking. 66, 70 documents in the name of my grandfather, father, and linkage issued by Gaura. Hello? Quran is it? Yes, that may be seen. page 24. Puran Bijni, Batinia Ami Madrasa, transfer living. Miss Saleha Khatun, daughter of Khandogar Jamaluddin, an inhabitant of village Puran Bijni, post office Bijni, in the district of Chirang, left the Puran Bijni Batinia Ami Madrasa on 31/12/93. Her age, according to admission register on that day, was 12 years. So here the resident is written as Puran Bijni. So that I have something is written against the document. Similarly, Kapanza certificate, I was for a few time at Sarke Basti, Lanka, but it is written that I took birth. So these are but 66 and 70. Yes. Yes.
Of Puran Bijni, Patinala Ami Madrasa. I know Saleha Khatun from the admission register of this school, where her name appears at serial number 23 and admission date is 19th January 1993. The name of her father as recorded in the admission register is Khandakar Jamal Uddin. Saleha Khatun stayed at village Puran Bijni when she was a student of the school. She took admission in class 5 of my school on 1993 and studied for 1 year and got promoted to class 6. Left the school. The certificate exhibit 2 has been issued by me to prove that she was a student of my school. Exhibit 2 is my signature in the certificate. So here is a person who was a resident of Puran Bijni.
Stays.
Chirang.
The word stay is there. Stays as Puran Bijni. Stays.
Stayed at village.
Yes.
Where you have stated in your written statement that the proceedee stayed at Puran Bijni.
She read only, that is stated.
You have also said that it is 3-4 kilometers away. Just now you have made a statement.
Yes.
But apparently this particular proceedee stayed at Puran Bijni.
Stays. Well, stay and taking birth, it is a little difference. A person may.
What, Mr.
So,
Amibam?
and
Yes,
that
you wanted to say certain decisions.
Yes, Lordship.
Please.
Lordship, first is Basiron Bibi versus Union of India. It is reported in 2018 1 GLT 372 paragraph
2018.
18 Lordship 1 GLT 372 paragraph 30 I'm relying on, but I do not know the paragraph in the citation. 30, no? Lordship, may I read it? It is on the voters list. Reliance placed in the case of Abdul Matali and Matlab Supra can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decisions that the said decision did not lay down any law and was a decision confined to the facts and circumstances of the case. Regarding discrepancies in the voters list which the petitioners contend were not her creation being entered into by officials of Election Commission and therefore should not be used adversely against the petitioner, such contention is without any substance. The voters list were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portion of the voters list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. This is relating the voters list, Lordship. Second, I am relying on WPC 7669 of 2016. Borhan Ali to
WPC
7669.
of 2016.
Yes, Borhan Ali. Paragraph 27.1, 28 and 29, Lordship. This is also related to voters list. And it says, if a proceedee relies on a voters list, he has to rely on the same in its entirety and not in part. He cannot say that he will rely upon the parts of the voters list which is favorable to the proceedee, but would not rely upon that part of the voters list which goes against him. For example, vital discrepancies in name, residence and age. A document has to be appreciated as a whole, not in bits and pieces. Then Lordship, paragraph 28, insofar section 90 of the Indian Evidence Act is concerned, deliberation of the same is not necessary as the petitioner has failed to establish his linkage with his projected father and grandfather. 29, I'm relying on 29 also, that being the position, we are of the unhesitant view that the petitioner has failed to discharge his burden under section 9 of the Foreigners Act of 1946 to prove that he was not a foreigner but a citizen. Lordship, I'm even relying on 2016.
Just a minute.
Yes, Lordship.
Just a minute. This is Borhan Ali you are talking about.
Yes, Lordship. 7669, 2016.
क्यों है? हाँ, उसको टाइप बोले इसलिए तो मारे लो ना ये तो गुंडों
13, no? Paragraph 13. $790. Para 8.
नॉमिनल प्रोल राइट नॉमिनल प्रोल
Itu as the Nikki. 16 to 45.
which para
Lordship 27, 27.1. We'll start from 27.1, 28 and 29. Lordship, next I'm relying on
next
Lordship, next is 2022 SCC online 1296, paragraph 13.
2022
Yes, Lordship, 2022 SCC online 1296, paragraph 13.
what is the party's name?
Party's name, Lordship. This is on the fraudulent documents which have been used. Fraud vitiates everything.
Do you have party's name?
We're just giving, Lordship may take down another one also. This is, we'll give the names, Lordship. 2016 4 SCC 790, paragraph 8.
790.
790, paragraph 8. Lordship, the first one, 2022, the party's name is Munjal Shova, Munjal.
Just a minute. Munjal
Shova, SHOWA Limited,
SHO.
WA. Munjal Shova Limited.
SHOA
SHOWA, I think.
Limited.
Yes, Lordship. Paragraph 13, Lordship.
MUNJAL.
MUNJAL. 2022 SCC Online 1296.
Okay. Kindly read.
Yes, sir. Lordship, 1 second.
Do you have it?
Yes, Lordship, you've got it on the. Paragraph 13. Lordship, I'm reading paragraph 13, 12. While opposing Lordship, itu nih. ऐसे कुछ ऐसे नहीं है. May I read, Lordship? While opposing the present appeal, Shri Vikramjit Banerjee, learned ASD, has submitted that in the present case, admittedly, the DEPB license scripts purchased by the appellants, of which the exemption benefit was availed, are found to be forged and fake. It is submitted that therefore the appellant, being beneficiaries of such forged and fake DEPB licenses scripts, were liable to pay the customs duty of which the exemption benefit was availed against such DEPB licenses. It is submitted, Lordship, that as rightly observed by the High Court as well as by the tribunal, that fraud vitiates everything, and therefore such forged fake DEPB licenses are void ab initio. This is the paragraph which I am referring to, Lordship.
Paragraph
13, Lordship.
It starts with
It starts with, I just read, Lordship, while opposing the present appeal, Shri Vikramjit Banerjee. 15 also we would like to rely on, Lordship, from the judgment and order passed by the tribunal and even from the findings recorded by the department. It has been found that the DEPB script licenses on which exemption benefit was availed by the appellant as buyers of the forged fake DEPB licenses were found to be forged once, and it is found that the licenses were not issued at all. A fraud was played and the exemption benefit was availed on such forged fake licenses. In that view of the matter and on the principle that fraud vitiates everything and such forged fake DEPB licenses are void ab initio, it cannot be said that the department acted illegally in invoking the extended period of limitation. In the facts and circumstances, the department was absolutely justified in invoking the extended period of limitation. It is Lordship, it is the same thing. Here the tribunal has also held after examining the documents and the witnesses that the documents produced before the tribunal were all fake and manipulated, Lordship. The serial numbers, dates may be same, but the actual document with the government was different and the one issued produced before the tribunal was different, Lordship. Lordship, there is one more we would like to rely on. 2016 4 SCC 790 para 8. Dr. Shashwati.
2015,
2016
Huh.
4 SCC
that you have said 2016, 4 SCC
Yes.
790.
para 8.
Huh.
And that is also, Lordship, I will just read that also. Output. 2, 3, 6, Lordship. It's relying on in Ramchandra Singh versus Savitri Devi, it was thus held. Fraud, as is well known, vitiates every Solomon act. Fraud and justice never dwell together. Fraud
Say
is conducted.
490,
Yes, Lordship. 790, Lordship.
2014, 16.
2016 4 SCC 790. It will be skipped. More details.
Sorry. Two 2016 4 SCC 790, right?
Yes, Lordship. Paragraph 8. We will give a copy of this, Lordship.
It has come here.
2016 4 SCC, no?
Is
790.
it 2016?
Yes, Lordship. It is.
4 SCC 790.
Yes. Those who appear are ऊपर जा कर देखो. 791. My friend is helping me. It's 791, Lordship. 2016 4 SCC 791. Sorry, Lordship.
Doesn't.
Lordship has found it. May I read it,
You are
Lordship?
reading para 8.
Yes, Lordship. In Ramchandra Singh versus Savitri Devi, it was held there. Thus, fraud, as is well known, vitiates every Solomon act. Fraud and justice never dwell together. Fraud is a conduct either by letter or words which induces the other person or authority to take a definite determinative stand as a response to the conduct of the former, either by word or letter. It is also well settled that misrepresentation itself amounts to fraud. Indeed, innocent misrepresentation may also give reason to claim relief against fraud. A fraudulent misrepresentation is called deceit and consists in leading a man into damage by willful or recklessly causing him to believe and act on falsehood. It is a fraud in law if a party makes representations which he knows to be false, and injury ensues therefrom, and although the motive from which the representations proceeds may not have been bad. An act of fraud on court is always viewed seriously. A collusion or conspiracy with a view to derive the rights of others in relation to a property would render the transaction void ab initio. Fraud and deception are synonymous. Although in a given case, a deception may not amount to fraud, fraud is anathema to all equitable principles, and any affair tainted with fraud cannot be perpetuated or saved by the application of any equitable doctrine, including res judicata. Fraud and collusion vitiate even the most solemn proceedings in any civilized system of jurisprudence. It is a concept descriptive of human conduct. I can go on, Lordship. There is whole We are relying on this, and Lordship, again, I would like to cite two judgments on certiorari also. If one is the latest judgment by the Supreme Court, Lordship, 2023, paragraph 50 onwards, under what condition writ of certiorari can be issued. And another is Santlal Gupta, that is 2016, 13 SCC, 336, paragraph 28. Paragraph 28 is a small paragraph, Lordship, if Lordship allows me to read it. May I read it, Lordship?
Please.
The High Court ought to have considered that it was a writ of certiorari and it was not dealing with an appeal. The writ of certiorari under Article 226 of the Constitution can be issued only when there is a failure of justice, and it cannot be issued merely because it may be legally permissible to do so. There must be an error apparent on the face of record, as the High Court acts merely in a supervisory capacity. An error apparent on the face of the record means an error which strikes one on mere looking and does not need long drawn out process of reasoning on points where there may be conceivably two opinions. Such error should not require any extraneous matter to show its incorrectness. Such errors may include the giving of the reasons that are bad in law or inconsistent, unintelligible, or inadequate. It may also.
You are reading 2016, 13 SCC,
Yes, Lordship.
page,
It's paragraph 28, Lordship.
which
Page,
page?
uh,
2016, 13 SCC,
no, Lordship, 2000. I'm reading Santlal Gupta. This is 2010, Lordship. 2010, 13 SCC, page 336.
yes.
Such errors should not require any extraneous matter to show its incorrectness. Such errors may include the giving of reasons that are bad in law or inconsistent, unintelligible, or inadequate. It may also include the application of a wrong legal test to the facts found, taking irrelevant considerations into account and failing to take relevant considerations into account, and wrongful admission or exclusion of evidence, as well as arriving at a conclusion without any supporting evidence. Such a writ can be issued when there is an error in jurisdiction or authority whose order is to be reviewed has acted without jurisdiction or in excess of its jurisdiction and has failed to act. While issuing the writ of certiorari, the order under challenge should not undergo scrutiny of an appellate court. It is obligatory on the part of the petitioner to show that a jurisdictional error has been committed by the statutory authorities. There must have been a breach of principles of natural justice for resorting to such a course. And the Supreme Court latest judgment, Lordship, 2023 SCC, online 996 Central Council. Lordship, that is the Central Council for Research in Ayurvedics.
2023 SCC online, it has been reported somewhere.
Yes, SCC 996, Lordship. Paragraph 50 onwards.
That's good. It was placed earlier by Mr.
Yes, Lordship.
I have few citations I have. May I?
We'll come back at 2. We'll come back at 2. Your junior will be here. We need some clarification from madam.
Maybe at 3, because at 2 I have another item fixed, it port number
She will
7.
be here. We'll just clarification from madam. Or if you want to come back at 3, you come back at 3. We'll
Yes.
hear it at 3.
Yes.
Yeah?
Okay.
You give the explanation and we just need certain
Yes,
clarification.
Lordship.
Then we'll take up with it. Where is Ms. Verma? Mr. Payang, in the passport, we have seen that only one particular document, that's the Gaon Panchayat Secretary's
Yes,
document. Where there is a submission that it was found to be the fraud one because the receipt number reflects another name.
Yes.
But the certificate exhibited before the tribunal is of having a different. But leaving aside that, even that is not accepted. Let us assume exhibit 1 is not accepted to prove, and that particular document is only with regard to the lineage, with regard to NRC. nothing
Yes.
to do with the citizenship. So how do you explain? What is the requirement of these judgments of fraudulence and others?
No, my lord, as per the judgment 2016, my lord, the misrepresentation itself is a my lord fraud. The documents, my lord, once the documents, if they taken a my lord fraudulent,
No, let us assume that document is not considered.
yes,
for
my lord,
the purpose.
if it is ignored, my lord, why we have submitted the judgment? My lord, because our point is that, my lord, if they have taken a fraudulent means, my lord, the entire proceeding will go.
So you want to submit that
They have
since the
taken,
prosecutor has obtained a fraudulent means for
Yes, ma'am.
prove her citizenship.
yes, somehow.
So whatever she has submitted by placing one fraudulent document, that will the entire proceeding.
Yes, entire proceeding will go.
That is your.
That's why, my lord, that the judgment has been placed, my lord. And other aspects, my lord, apart from that, that is one point in the case, my lord, because if the, my lord, it is a certain proposition, my lord, if a fraudulent activities has been taken place, or if she try to take a the proceeded trying to take a, my lord, fraudulent fraud documents, and if it is proved that it is a fraud, and she has taken that, my lord, that fraud has been proved, then with the entire proceeding, that will affect that it will vitiate the entire proceeding, madam. That is the law.
Okay, we'll get the clarification from Mr. Mahmood. Let him come at 3 o'clock.
Yes.
You be here. Just.
Yes.
everything. We'll have it during his presence.
Yes.
Possibly,
May it please your lordship. My lords, the petitioner, in order to substantiate her claim to be the lineal descendant of a bona fide citizen of India, your lordship, she has relied upon as many as 9 exhibited documents submitted before the learned tribunal, your lordship. Right from the voter list of 1966, 1970, 1966 and 1970, the voter list of the parents of the petitioner, your lordship. 1966 is page 25, your lordship. The name of the father of the petitioner appears serial number 73, house number 20, Abdul Karim. So then, your lordship, 1970, page 26, your lordship. Here also the father, name of the father appears as serial number 70. And rest of the 2 person indicated in the voter list are the family members, your lordship. So after marriage, your lordship, the name of the petitioner did appear in the voter list of 1997, your lordship. Page 90, page 27. 97 to onwards, that is up to 2016, 2010, your lordship. The name of the petitioner appears. With her husband after entering into marriage, your lordship. So in order to establish the linkage, Your Lordship, one document being submitted before the Learned Tribunal, that is the test 41, Your Lordship. That is the voter list, that is the certificate issued by the Panchayat Secretary, Your Lordship. So here, the certificate issued by the Secretary indicated all the details of register certified that Johra Khatun Bewa, daughter of Abdul Karim of Kukila Part 1, village Chabantar, Season Revenue Circle of Bongaigaon, has at about 45 years as a resident within the jurisdiction of the Sheikh Panchayat area. He got married on 1/3/1990, Your Lordship, with one Sarfan Ali, son of Hasimuddin Mia of village Kukila Noyapara, in the same district, Your Lordship, under the same revenue circle. And Your Lordship, another document here next with this writ petition, Your Lordship, could not be exhibited before the learned tribunal, that is page 42(1) Jamabandi copy, where the name of the father appears, along with the legal years. After the death of the father, the name of the legal years appears in the copy of Jamabandi, and the name of the petitioner is also there at serial number 5, Johra Khatun, page 42, Your Lordship. Your Lordship, so I have gone into the, Your Lordship, the opinion passed on dated 30/11/2016. The learned tribunal disbelieved the document submitted by the petitioner and also did not give credence of the deposition, Your Lordship, given in the form of evidence in chief before the learned tribunal, Your Lordship. So only Your Lordship pointed out that failed to establish the linkage. So from the document, your lordship, it appears that I have succeeded in discharging my burden under section 9 of the Foreigners Act, your lordship, 1946. But the prosecution failed to revert or demolish the version what had stated before the learned tribunal. And also did not raise any question regarding the authenticity of the documents submitted by the petitioner. And also the more pertinent question regarding the linkage, your lordship, that did not say anything before the tribunal by the prosecution that this document is not valid or authentic to establish the linkage. So Jamabundi is an important document, could not be exhibited before the learned tribunal, but it is before your lordship's consideration, your lordship. We received it subsequently, your lordship. And therefore, in the writ petition, we have, so it's your lordship's consideration, your lordship, if allowed. Because this is a very vital document.
Verma. Mr. Devan, just tell us one thing. As per the Evidence Act, value of translated copy of electoral rolls, certified copy of translated copy of electoral.
Certified copy of electoral roll is as per evidence, it's a public document, your lordship.
That's true. Now, translated copy. You have exhibited
Lordship,
certain documents, right?
lordship. Besides, some, those documents, your lordship, I have exhibited some other document, which could
You have
not be,
executed voter list of 1966,
lordship.
1970, 1997, 2005, and 2010, where your name figured.
Up to 2010, your lordship. So rest of the voter list,
Now, 1966 is the voter list.
1966 is the voter list of her father, Abdul Karim. Is the
Now-
father of the petitioner.
Is it a certified copy or translated copy?
Lordship, as per the information, your lordship, instruction derived, your lordship. These are certified copy, your lordship.
Where it is written as a certified copy? In the exhibit?
Because it is, because you lordship, in the left portion, you lordship, compared by. Where it is compared by is indicated, there's a, only in a certified copy is compared by.
Do you have the Evidence Act with you? Read section 76.
It is for you, correct? Lordship, uh, may I take the help of your Lordship mobile phone?
Doesn't matter.
Lordship. So section 76, your Lordship. Every public officer having the custody of a public document, which any person has a right to inspect, shall give that person on demand a copy of it on payment of legal fee, therefore, together with a certificate written at the foot of such copy that it is the true copy of such document or part thereof as the.
Now kindly see the exhibit A, B, C, D with the 5 voter list you have exhibited before this. Mentioned there,
Right from 1966, your Lordship.
whether it can be considered in the under the provisions of the section 76 of the Evidence Act. First of all, it's a translated copy.
Lordship.
The issuing authority hasn't identified it. There is no evidence of the issuing authority. They have not placed the original one. It has to be from the original one. It's a translated copy. Plus, there is no mention that it's a certified copy of the true copy. That's what the section 76 says.
Lordship.
Now just
As
see,
per section 76, your Lordship. So for the document, your Lordship, annexed in this writ petition, your Lordship.
Mm.
As per 76, your Lordship, it should have indicated, your Lordship, that the certified copy. But here it is not, your Lordship. But as per instruction, your Lordship, they have applied for as to due process, your Lordship, by
That will
submitting
not-
legal fee, etc., your Lordship.
that is not
But-
possible to believe. Now, just show you something from your own document. Come to page number 25.
Page 25, your Lordship.
With due process you have applied for, right?
Lordship.
What is the stamp number? At the top, 1010. Date is written 15th of October 2012. Then how come the junior assistant election officer signed that document on 6th of October 2012? When the stamp is of 15th of October 2012. Similarly, page 26. Then come to page number 28. Stamp number 2360, date is 5th of October 2012. You got it on 1st of October 2012. Fine.
Lordship.
Then come to page number 30. It is 14135 of 16th October. It was already compared on 15th of October. Do you say that these are due process? You have the written statement with you?
Lordship, this two written statement as well as your Lordship, this evidence in sheet. these two that could not be, Your Lordship, in my writ petition, Your Lordship. In the LCR, Your Lordship,
We have not annexed.
because that time at the relevant point of when I had filed this writ petition, at that time it was not available, Your Lordship. So thereafter, Your Lordship, they were asked to bring, Your Lordship, but WS filed on, Your Lordship, I have this statement. Uh, four 2012. So, no.
Page 25.
Lordship.
Who is your mother?
Page 25.
Who is your mother?
His Lordship, this Paku Bibi.
Where from you are saying? In which certificate it has been mentioned? Now at page 25, serial number 74.
Serial 74, Your Lordship. Daliman Nasa is the sister, Your Lordship.
Dalimun Nesa's
Sister,
father's name is what?
Lordship. Daliman Nasa's father's name, Your Lordship. Father's name is, Your Lordship, Abdul Karim.
Abdul.
The name of Abdul only comes here in the Lordship, but it is Abdul Karim, Your Lordship.
Then serial number 77.
77, Your Lordship, Paku Bibi.
Her husband is?
Abdul Karim.
So Dalimun Nesa's husband is also Abdul Karim. Paku Bibi is also Abdul Karim. Now, who is your mother?
Daliman Nasa is the sister, Your Lordship.
Your mother is of 30 years, your sister is of 38 years. Page number 26. Where is now Paku Bibi?
Paku
In the
Bibi,
voter list of 1970. She left for somewhere else.
page numbers 26.
26.
Paku Bibi, the name of Paku Bibi is not there, not here, Your Lordship.
So,
Only Abdul Karim and Daliman Nasa is
so
there.
who is your mother now? Why your name did not figure prior to 1997 in the hotel list?
The name of the Your Lordship.
Hmm?
In 1997, Your Lordship is the rustic villagers, Your Lordship.
Hmm.
So, because when
Why only after your marriage,
after marriage, Your Lordship, the name appears with her husband, Your Lordship.
while he
Uh,
was,
24 years of age.
why only India 1997? From 1989 itself, 18 years is the voting age.
Lordship.
Why her name did not figure earlier?
So 1997, Your Lordship.
Which is your link document?
Link document is Your Lordship, is at page 41, Your Lordship.
Now, whether this document has been proved by the issuing authority,
It's not proof, Your Lordship.
then if your link document is not proved, how will you establish your case to be an Indian citizen?
So, Lordship,
Question of-
Lordship, my respectful submission before your Lordship. So far the documents submitted before the tribunal as well as in this instant writ petition, Your Lordship. Some additional documents also been filed, Your Lordship, in the writ petition, Your Lordship. So, Your Lordship, in the last document is 43 page number, Your Lordship. That is copy of Jamabandi also there, the name of the petitioner is there with the father, Your Lordship. So after the death of the father, Your Lordship, his brother's name as well as other members did appear, Your Lordship, as a legal heir, Your Lordship. So my name is also there in page serial number 5, Your Lordship. So my response at that point of time, Your Lordship. So had she been properly instructed, Your Lordship, documents are there, Your Lordship. But the thing is that Your Lordship, not duly instructed by Your Lordship, had she been, because she's an illiterate person, Your Lordship. And also a lady, Your Lordship. Husband is also not there, Your Lordship. So had she been properly instructed, Your Lordship, certainly she could have discharged her burden under section 9 of the evidence, Foreigners Act, Your Lordship. So, Your Lordship, is the Lordship prerogative, Your Lordship, if allow, and the sons.
You are challenging the order. Who are we? Only to verify the order is gathered good in law.
Lordship.
On 28th of September.
Lordship, I am agree with you, Lordship.
On 28th of September 2016.
Lordship.
The counsel for the proceeding submitted an affidavit.
Lordship.
Before the tribunal. Requesting.
And also, Your Lordship, although I have exhibited as many as 9 documents, Your Lordship, but in the judgment part, it is not all the details, Your Lordship.
Listen, requesting the tribunal to produce before it a particular document which could not be placed earlier.
Lordship.
And that is the link document.
That is the only link document.
Which you have just read.
Lordship, Lordship.
And that paragraph 5 of that affidavit by the concerned lawyer of the petitioner clearly stated like this. Before passing any order, the opposite party prays before your honor to give an opportunity to prove her nationality by way of filing the original document along with the linkage certificate that the opposite party is the illiterate lady. The linkage certificate issued by the block development officer was in custody of her husband who was in Delhi for his livelihood as such could not be able to produce the same before the honorable court earlier, that the husband of the opposite party came to home on 24 March 2016, and hearing the same, he shown it to her engaged advocate and submit the same before the tribunal today without any delay. Here, the husband of the proceeding was at Delhi, who came home on 24th of March 2016 and was having this particular certificate issued by the Gaon Panchayat authority and accordingly placed before the tribunal. The tribunal accepted as document H, right? So if you have not proved it, what to do? Tribunal has accepted it. That is why in the judgment they considered that one point of time the petitioner says that she is a widow. But at the same time, this document was with her husband who was at Delhi earning his livelihood, who came home only in 24th of March 2016 and accordingly it was immediately placed on 28th. Because at the time of return statement, that document was not there. Right? The return statement, as you have pointed out, was filed on 4th of December 2012. And this document is of 1st of July. Oh, sorry, it was of 30th of June 2015. Charter signed by the BDO on 1st of July 2015. What else? What else?
Your Lordship, only Lordship, so far the documents submitted before the tribunal, Your Lordship. And as per information derived from my client, Your Lordship. The documents are there, sufficient documents are there, Your Lordship.
Sufficient means more than sufficient. But we have not proved those documents.
More than sufficient documents are there, Your Lordship. So that point of time, Your Lordship. So it's a
We have
very.
wrote the judgments of the effect.
So
Number
Lordship,
of documents will not do, only one document will do. If
Lordship,
you can prove the
because
lineage.
it's a citizenship right, Your Lordship, is a very vital one, Your Lordship. So I'm not denying the fact, Your Lordship, that the fail to prove in a proper manner, Your Lordship. But on humanitarian ground, Your Lordship, the husband is also, Your Lordship, not there, expired, Your Lordship. So, Your Lordship, at a chance, may Your Lordship an opportunity.
Was while exercising the power under Article 226, more particularly the statutory, you can do that.
Otherwise, Your Lordship, so far the going into the Your Lordship, the opinion part, Your Lordship. The only link document is, Your Lordship, this linkage are issued by the Panchayat Secretary. So that failed to prove as per Indian Evidence Act.
That was after the
That could not be done, Your Lordship. So far the Indian Evidence Act is concerned, Your Lordship.
that was after the written statement.
Yes, Your Lordship.
So
To bring, Your Lordship, the linkage with the father, Your Lordship. But, Your Lordship, I am stressing, Your Lordship, on one document there is place 43, Your Lordship, although it could not be, Your Lordship, that point of time, Your Lordship.
Hmm.
But subsequently, Your Lordship was obtained, Your Lordship. So, Your Lordship,
That land document.
land document, Your
Land.
Lordship. Land page, para, Your Lordship, point number 5, Your Lordship. And it is also not there in the judgment that this could not be produced, although it was at the disposal of the petitioner subsequent to Your Lordship, this pronouncement of this giving opinion, Your Lordship. Some lenient, Your Lordship. A lady.
This is of which year?
This is of Your Lordship. 2017, Your Lordship.
Okay.
2017.
When the order was passed?
Order passed in Your Lordship on 2016. Your Lordship. Order passed on 30/11/2016, Your Lordship.
So the procedure was aware that her father had land in his name. Have you mentioned in your written statement? If you have not mentioned about any such property of your father, suddenly can you bring a document and place it before the High Court
Because
and say that you should be returned back for consideration?
Your
You
Lordship.
have not stated before the tribunal.
That was not done, Your Lordship.
Then
Only after pronouncement of some judgment from the Honorable Supreme Court that all the details need to be, Your Lordship, reflected in the written statement. So that point of time, Your Lordship, it was some casually,
have you stated so before the tribunal?
that was not, Your Lordship.
Have you stated when your
No,
father
not stated, Your Lordship. So after recital of the, Your Lordship, all the documents, Your Lordship, submitted before the in the form of in this writ petition, Your Lordship.
We could have considered, if you have stated so before your tribunal, that your father had landed property.
So I beg your indulgence, Your Lordship, that at the time of filing the writ petition, I could not, Your Lordship, I could not produce this written statement as well as the evidence in chief.
So
But it is there in the LCR, Your Lordship.
the thing is, that's the reason we want to know. If you have not
It
mentioned
is
in
there
your,
in the LCR, whether it is written statement, it is there or not. I am not conversant with the fact, Your Lordship. But because that point of time, that is the look, that is some of the,
why it is already there in the Sarvanda Sonwal 1,
yes, Your Lordship, that time it was,
the judgment of this particular is after Sarvanda Sonwal.
yes, Your Lordship. A last chance, Your Lordship.
So
It is only, Lordship, it is only to the acceptance, Your Lordship. Is consider this Jamabandi copy.
that is the reason we are asking you, have you stated so that your father had land property in your written statement? Have you mentioned so? If it is not there, not there. Anything else you want to submit?
Lordship, ignorance of fact is an excuse, Your Lordship. And ignorance of law is not an excuse. It is an, usual Lordship considered is an ignorance of fact, Your Lordship. That's
That's all.
Lordship. My respectful submission, Your Lordship, right from 1966. Because Your Lordship, I am trying to establish relation with my father, Your Lordship. So right from 1966, Lordship. So my father name is Diyar, Your Lordship, and the grandfather name is late Abed Ali. So 1970 also my father name is Diyar, Your Lordship. So far the name of the petitioner party is concerned, Your Lordship. Her name ought to have appeared, Your Lordship, at the age of 19 or 20, but 5 years later got appear, Your Lordship, in the voter list of 1997. Although it should have appear before 1997, 89. It is only because of the fact, Your Lordship, this illiterate person, they are not that much of familiar to the fact that as and when enter into the age of, Your Lordship, voter.
Law is equal for all, or law is equal for unequal?
Law is equal for all, Your Lordship. Law is equal for all.
So whether it's literate.
So my respectful submission before Lordship, Lordship also gone into the records, Your Lordship, that 66 voter list is there, 70 is there, Your Lordship, 97 to 2010.
That is the reason I have asked you.
97 to 2010, the name of the petitioner herself indicated in the all those voter list, Your Lordship. And besides all those voter list, Your Lordship, the copy of Jamandi also there, Your Lordship. And one linkage document is there, Lordship, but they failed to prove the same before the tribunal. Only document submitted. Had the petitioner been conversant with the fact, but it is the only engaged counsel who it is the duty of the engaged counsel to let.
Unless the procedure says something before the engaged counsel, how the counsel will know who is your father, who is your mother? The procedure have to explain who is her mother, who is her father.
Lordship,
Don't blame because you are also a counsel.
Lordship,
Don't blame the counsel for that.
Lordship, I am withdrawing, Your Lordship. Actually, I am not putting the blame on advocates, Your Lordship. Sometimes it's happen, Your
Procedure
Lordship.
has to explain.
Lordship. So my lord, my lord, my lord,
Anything extra you like to add?
anything, Lordship, my last submission before Lordship, if my submission, Your Lordship, before Your Lordship, with the help of all these documents, Your Lordship, find any place on humanitarian ground, Your Lordship.
Is it acceptable?
That
Can
may
you do
kindly
it?
because Your Lordship, it's a very vital, very vital citizenship right, Your Lordship.
Okay.
Is it subject to correction, Your Lordship? Is it a fact, Your Lordship? Although I need to you instruct the learned counsel in a proper manner, or I need to lead the case in a proper, but fail to do so, and because of that, consequently, as a consequence of that, Your Lordship, what I am today, Your Lordship, suffering from all this.
In the voter list of 1960 and 1970, 1966 and 70, we ask you whether it is applicable under section 76 or not, whether it is a certified.
That so far the definition is concerned, Your Lordship, not applicable. Definition
Leaving
is
aside that, whether is voter list of the 66 and 70, is it of Abdul Karim Mandal or of Abdul Karim?
Abdul Karim, Your Lordship.
If it is a voter name is Abdul Karim, it is only Abdul Karim. It has nothing to do with Abdul Karim Mandal.
Name discrepancy and age discrepancy is a very
Sure,
prevalent
there.
issue. Some name discrepancy and more particularly age in all these cases, mostly prevalent, Your Lordship. Sometimes Mondal, sometimes Devani, because in village some common colloquial words are being used, Your Lordship. If he used to held some bisar or holding some meeting, etc., assembling with people in the locality, he is called as Devani, Your Lordship. So sometimes in the Buddha list it comes as Devani, although he is not named after Devani. Munshi, sometimes Munshi. Munshi means those who, Your Lordship, attending some ceremony, etc., Your Lordship, in the feast, they are Munshi like. So it is up to the acceptance of Your Lordship, my respectful submission, Your Lordship. Under 226 of the Constitution, Your Lordship has ample power, Your Lordship. That I have failed, Your Lordship, in some. And so far the land document is concerned, Your Lordship, from my common understanding, Your Lordship, I did not get any information. From my common understanding, Your Lordship, since at the relevant point of time, Your Lordship, that this copy of Jamabandy could not be annexed or exhibited before the tribunal. So therefore, while preparing the written statement, since the document itself is not at the disposal of the
See,
party
if
concerned.
you read the written statement of the petitioner,
So
she
since
is very intelligent.
Lordship,
She is very intelligent. In her written statement, she did not spell out the name of her father, name of her mother, not even the name of her grandfather. She remained silent, excepting her husband.
except husband.
She only named her husband. They did not name her father, mother, grandfather, nobody.
But this is a
That is the
very
reason she doesn't know who is her father. That is why she doesn't know whether her father had land or not. All discovery. Right? She did not name her father, mother, nobody. Except her husband. Yes, Mr. Payne.
No, before going to the facts, my lord, just as my learned friend was asking, that she's a poor lady, it's an important right of citizenship. My lord, just I like to point out one paragraph of Sarbananda Sonowal to 1, my lord.
Para 23.
No, my lord. Para 62, my lord.
Hmm.
The IMDT was silenced in that case, my lord. In the IMDT, the object, what was the object of the IMDT? In the first line of the IMDT, my lord, it was written, the influx of foreigners who illegally migrated into India across the borders of sensitive eastern and northeastern region of country and remain in the country pose a threat to the integrity and security of the said region. This was the object of the IMDT Act, madam. And this is the my lord, legislation legislature who has given this introduction. Now, my lord, the Sabananda para 63, my lord, there it is the Supreme Court says, this being the situation, there can be no manner of doubt that a state of Assam is facing external aggression and internal disturbance on account of large-scale illegal migration of Bangladeshi nationals. It's therefore become the duty of the Union of India to take all measures for protection of the state of Assam from such external aggression and internal disturbance as enjoined in the Article 355 of the Constitution of India. So I accept, my lord, the citizenship right is an important right, but the people, the external aggression and internal disturbance of the state of Assam is more important because it is in the public interest. My lord, the public interest prevail over the personal interest. A person whose citizenship is in doubt, he is claiming that, my lord, his citizenship right is important, but the most important is, my lord, the external aggression and internal disturbance of the state of Assam is concerned. So that is in public interest. That interest prevails over the, my lord, personal interest. And this is, my lord, para 63 Sarvanant rules. It is Honorable Apex Court has said this is an external aggression, and so they may not be, my lord, if a country, the country has to be protected by the state. The state had failed to protect the people of the state of Assam. And this was the, my lord, understanding of the Honorable Apex Court, and said this is more important. That is only for the reference, my lord, as my learned friend was asking, the citizenship is an important right, my lord. Sobananda Sunal 2005 5 SCC, my lord. Para 63. And that is more important. 2005 5 SCC 665, my lord. Para 63 may be not done.
একেলগে পাঁচটা এই ডিপি ট্রান্সফাৰৰ ডিপি ট্রান্সফার সিরিজ নাই লাইব্রেৰী আছে আমি প্ৰত্যেক লাইব্ৰেৰীতে দিয়া আছে প্ৰত্যেকটো ফটোতে দিয়া আছে না ভিডিঅ'ত নাই এই আলমাৰী কেইটা খোলা ওলাব পুৰণাটো Okay, next.
Next, my lord, now coming to the facts of the case, my lord, as your lordship has already pointed out, though the WS has not been annexed, but in WS, what I have found, my lord, she did not mention she fails to bring the material facts in the WS. She did not mention her parents, grandparents' name, nor about the land, neither about the, my lord, the GP certificate, the link certificate, which she is trying to, my lord, prove, trying to bring as a link certificate. That is a first failure. Secondly, my lord, one thing my learned friend has just now pointed out, who is the mother. As per, my lord, if we, your lordship, we see the 1966 voter list. They are claiming that this Paku Bibi is her mother. And Paku Bibi was in the voter list of 1966. Now in 1970, Paku Bibi is no more. What happened to that Paku Bibi? Whether she died, whether she have migrated somewhere, that has not been disclosed. Now, my lord, if we see the voter list of 1997, the petitioner Zohura Khatun, in fact, she is Zohura Begum. Here she is claiming that she is Zohura Khatun. And Zohura Khatun is aged about 24 years in 1997. And if we calculate, my lord, Zohura Khatun's date of birth will be sometime in 1973. Now, in 1971, Paku Bibi is no more. If mother is not there, how can she be born in 1973? Because as per this 1997 voter list, says 70, her date of birth will be sometime in 1973. And from 1966 onwards, in fact, in 1970, Paku Bibi is no more. So when mother is not there, how can she be born in 1973? That is factual aspect, man. That is not nowhere it is explained, no pleadings at all to that effect. So in 70, Paku Bibi is not there. 73, her date of birth. And prior to 1970, 97, there is no voter list of this petitioner. That is another aspect, madam. And now she is trying to bring the voter 1997, this Gaon Panchayat certificate, which is the vital documents to prove herself, prove her link to the Malad Abdul Karim of 1966 and 70. And interestingly, this certificate has not been proved. And unless and until it is proved, my lord, it has no value at all. This certificate has no value at all. And as your lordship has pointed out, the voter list of my lord, the translated copy of the voter list. So this this cannot be taken as secondary evidence, even secondary evidence for the purpose of under Evidence Act, my lord. And another thing, my lord, she has tried to misrepresent the court. What I have submitted in the earlier case also, this amount of fraud, in fact, my lord, because in one state states that her husband died, and in the next state, my lord, in another state, she said that her husband is in Delhi, so he was in Delhi, so the certificate was in his possession, so it could not be produced on time. So now, after coming back from the Delhi, the certificate has been producing in the tribunal. This is totally, my lord, fraud. This amounts to a fraud. This is a misrepresentation. So under this provisions, my lord, I would just like to point out, my lord, as your lordship was questioning whether the translated copy of the voter list can be used as a piece of evidence under section 76 of the Evidence Act, my lord. To that effect, my submission will be it cannot be used as a secondary evidence. First of all, my lord, in fact, my lord, it is admitted position. They have not said that the documents are proved. Documents are not proved. The certificates are not proved. No evidence, my lord, of any other evidences were given except the, my lord, evidence of the, my lord, prosecution proceeding. Now, my lord, this is the judgment of this honorable court. This is 2460/2016, my lord. (2460/2016) disposed of on 10/04/2018, my lord. Isiran Nesa versus Union of India. There in the, my lord, the question was, my lord, may I read the relevant? It will be in page. It will be in page, my lord, 5. Page number 5, my lord.
Yes.
Second last paragraph from section 74 explains. Section 74 explains as to whether the public documents, and section 76 deals with the certified copies of the public document. As per section 76, every public officer having the custody of public document, which any person has a right to inspect, shall give the person on demand a copy of it on payment of the legal fees, therefore, together with a certificate written at the foot of such copy that it is a true copy of such document or part thereof, and as such, and such certificate shall be dated, subscribed by such officer with his name and his official title, and shall be sealed whenever such officers authorized by law or to make such use of a seal. Such copy, so certified shall be called certified copy. Now your lordship has seen there is no certification, no official designation, no name of the person who has issued this certificate. His name should be specifically mentioned, who has issued that certificate. Now, second part, man, here it is clearly statement. On careful and conjoint reading of the aforesaid provisions of the Evidence Act together with the definition of certified copy, we are of the unhesitated view that translated copy, such as Exhibit A and B, cannot be constituted as certified copies and therefore cannot be treated as secondary evidence. So, translated copy cannot be treated as as secondary evidence. This is So the translated copy of the voter list of 1966, 70, 97, this cannot be treated as matter of secondary evidence. And regarding the voter list of that Panchayat certificate, it is settled position that the Panchayat certificate has to be proved. Unless until it is proved, it has no value at all. This is my lord, the Rubjan Begum. Again, I would like to refer to Rubjan Begum, my lord, 2018 1 SCC 579.
One SCC.
Yes, my lord. 2018 1 SCC 579, my lord. Para 16, it is clearly said, my lord. Para 16 said the certificate issued by the GP secretary by no means is a proof of citizenship. That is first line, my lord. Such proof will come only if the link between the claimant and the legacy person who has to be a citizen is established. The certificate has to be verified at two stages. The first is authenticity of the certificate itself, and the second is the authenticity of the contents thereof. So, if the my lord writer himself does not appear before the court, tribunal, and give evidences, my lord, how can this be verified? So verification will not come. So it is the duty of the petitioner proceeding to prove that certificate as per this, and unless until it is verified, it cannot be accepted a piece of evidence. And this is settled in thereafter, my lord, this honorable court has in number of cases accepted this proposition. There are numbers of cases, my lord. This proposition has been accepted. In fact, this is accepted in 3910 of 2016, my lord. 3910 2016, Malida Bibi versus Union of India. This is disposed upon, my lord, 23/1/2018. There also, my lord, the Rubjan Bibi was referred, para 14, my lord. In that case, para 14. The Rubjan Bibi was referred, and it is that while holding that such certificate can be used for the purpose, it has, however, been made clear that a certificate issued by the government secretary is by no means a proof of citizenship. Such a certificate cannot be legitimately and validly used to establish a claim of citizenship. It is only to a linked certificate. It has to be verified at two stages, namely authenticity of the certificate itself and authenticity of the contents. Having regard to the above, we are afraid on the strength of such testimony. In fact, in this case, the Panchayat secretary appeared. Even after his appearance, his statement was seen, then also it is negated. But in the instant case, no, in fact, the petitioner, the author of the documents, he did not appear for proving the case. Contents certificate can be said to have been proved. So the Panchayat certificate is not proof. In absence of Panchayat certificate, my lord, there is no link at all. First of all, my lord, the factual aspect I have stated, the 66-70 voter list, this cannot be taken as a secondary evidence. Even though we accept it as a secondary evidence, then also the petitioner failed to prove by bringing cogent reliable evidence, that is the Panchayat certificate, was by not proving the Panchayat certificate. And another issue my learned friend has been is pressing this document, my last document, the 343 documents, the Jamabandi copy. This Jamabandi was obtained, and in fact, the mutation was done after the opinion was passed. And now, my lord, it is settled position. Not only now, it is a settled position. A declared foreigner cannot have, my lord, land in her name. She cannot have. It has to be, my lord, given back to the state. So, right to, my lord, land property is not there with a declared foreigner. Here, my lord, my lord friend is bringing this document first time in this before this honorable court, and my lord, as I have relied earlier also, but this time, my lord, I have it is clearly said in WPC 4020/2017, my lord. 4020/2017. This is Asia Khatun, my lord. Asia Khatun, it is pero. WPC 4020/2017, Asia Khatun, disposed upon 21/11/2019. There in para 8, my lord, it is said the petitioner have enclosed few documents with the writ petition for consideration, like the present document, my lord. We would observe that fresh documents introduced in the present writ petition proceedings cannot be looked into or considered, the same not having been produced, exhibited, and proved before the tribunal at the first instance.
It's not a court of appeal or
Yes,
something
ma'am.
like that.
Yes, ma'am.
4020.
Yes, 4020/17, my lord. Disposed upon 21/11/19. Para 8. In the next para, my lord, page number 3. Second last paragraph, page number 3.
Okay.
In the same line, my lord, I would like to refer the another judgment of this honorable court, that is 2021 1 GLT 799.
2021 on
1 GLT 799.
Seven.
2021 1 GLT 799. There in para 13, 10, 13, and 14, it is clearly discussed. I have earlier relied on this judgment, my lord. Even in that case, my lord, the new evidence was not allowed. Even the proceeding, after the completion of the, my lord, evidence. There the document, para 14 said, my lord, we find that the petitioner is seeking introduce evidence by recall a witness who is already available at the time when the defense witness were examined. The documents as indicated herein above are neither new evidence nor sought to be introduced, no new facts discovered subsequently. Thus, it's an apparent that only after cross-examination of the witnesses, the certain lapses in the evidence on the petitioner's side was noticed. The main purpose of order so is to enable the court while trying to clarify any doubts which it may have with regard to the evidence led by parties. The said provisions are not intended to be used to fill the omission in the evidence of a witness who has already been examined. So, there are 10 also. There are 10, 13, and 14, my lord. So in this case, my lord, in the present case, the petitioner is trying to bring these documents before this honorable court. And in the earlier judgment, it is said in certiorari jurisdiction, my lord, this honorable court has rejected to accept this kind of documents in the writ proceeding.
What is the judgment, Mr. Pine, that not necessarily required to be cross-examined by the
Yes,
government clear.
that is in
Because
fact.
it was, earlier you have.
Yes, yes. There are two judgments, my lord. First of all, I like to refer the para 26 of the Sarbananda Sunat.
That hearing it is already taken note of.
Yes, yes.
And then there was,
Another judgment of this honorable court, my lord.
as the duty lies with the proceedee,
Yes,
like in the previous matter in the morning,
yes.
the similarly, Mr. John also made similar argument that the evidence remain intact because it was not examined. There was no cross examination. No, if you do not have, give it to us tomorrow, no problem.
I can produce just after some time, my lord. Let me go. Is there?
Because- Give it to us tomorrow, no.
Yes.
Heard Mr. A. Diwan, learned counsel appearing for the petitioner. And Mr. J. Pang, standing counsel, Home Department, Assam, for the respondent numbers 2 and 3. As well as the Hazika Government Advocate, Assam, for the respondent number 4. No representation on behalf of the respondent number 1, Union of India. Here is the record. The Foreigners Tribunal concerned, wherein the impugned orders plus opinion dated 30/11/2016 was passed in Consent Tribunal, Minister Consent Tribunal, passed by the Foreigners Tribunal, Bongaigaon, number 2 of Raipur. In BNZ Big FT case number 972/2009, whereby the petitioner has been declared to be a foreigner under the Foreigners Act 1946, who entered into India from the specified territory of Bangladesh without authority on or after 25/03/1971. Foreigner / illegal migrant. List on 19 for necessary order.
Only the judgment I have got it.
You got it?
Yes, that is WPC 2641 of 2017.
2641
Yes, 2017.
and Sarvananda Sonwal.
No, no, no. That is WPC 2641 of 2017, State of Assam and other
No, no,
process.
that's right. Then another, you were also saying about the Sarvananda Sonwal.
Sarbananda Sunat.
Para
Para
26.
26 and. para
32, I
26.
think so.
Yes. Here, your lordship will find the question of rebuttal evidence by the state will arise only if the proceeding adduces evidence which are admissible, proof, and which have relevance.
That's
Then
what
only
it-
question of rebuttal.
A Mahmood to collect. Mr. Mahmood, my lord, sister has a single bench. Will rise for now. Your matter will be taken up tomorrow morning. Just by step we make it. Next step we put it. By step, but we will take it as item number 1. Other matters will be there, motion will be there. Immediately after a motion, we will take up your.
On the citation part is there, so
We'll just clarification. Got it.
yes.
You have to take it. Not to take.